Good morning. My name is Jeremy Simons. I'm a practicing attorney in the state of Florida, primarily practicing in family law, and I am one of the tutors for Ibis Prep. During your individual tutoring sessions, one of the components that sets Ibis Prep apart, if you have needs for family law, contracts, evidence, and civil procedure, I may be one of the individuals that you're working with. Today, we're going to talk about family law, and as you can see, the most important component of this lecture is for you to master JVPs and know when it needs a side of mustard, and you'll understand exactly what that means as we dive in. But make sure that you write that down, because that's how you're going to structure not only your outline, but also your essays, unless the essay writer instructs you to only specific issues they want discussed. That has happened in the past, where there's an essay where they direct you exactly to what they want, but in general, they will just have you analyze and advise a client, and this is the analysis that you go through. The first thing we're going to do is we're going to go through an outline, and then we're going to briefly go through some issue spotting, but I do want to talk about a couple ancillary issues. Now, not only is family law not tested on every Florida bar examination, but these two components are even more rare, but we're going to talk about them very briefly. Marital contracts and dependency. Now, marital contracts are your prenuptial agreements, your postnuptial agreements, and your marital settlement agreements. Those are your marital contracts. We are going to try and put together some materials specifically as to marital contracts so that you can brief yourself on them and recognize the analysis when you need it, but it's a little bit outside the scope today. There are two components that you must remember. One is that a marital contract is void if it's entered into under duress, fraud, or undue influence. This is the spouse 2 days before the wedding that forces a prenuptial agreement on the other spouse and says, you sign it or we're not getting married. That is the type of undue influence in the case law that has overturned marital contracts. The second one is inadequate financial disclosures. Almost all marital contracts, and especially prenuptial and postnuptial agreements, those contracts decide the obligation for marital assets and non-marital assets. In particular, most of the time they declare what would otherwise be a marital asset as a non-marital asset. So for one to contract away the right to marital assets, they have to know what those assets are. The two other small components is you cannot waive child support in a nuptial contract, and you cannot waive temporary alimony in a prenuptial or a postnuptial contract. Now, dependency, in my opinion, is not part of family law. It is assigned a separate division in every jurisdiction in the state. Most family law cases are marked with a DR for domestic relations. That includes all your various paternities, your divorces, your injunctions, your civil injunctions, and it is governed by Book 12 of the Florida Rules of Procedures, specifically the Florida Rules of Family Law Procedure. Now, dependency is governed by Chapter 39. It's a quasi-criminal and civil action, and it's governed by Book 8 of the Rules of Procedure. They have tested on dependency, and we will prepare additional materials and outlines on dependency so you can recognize it, but it is outside of the scope of what we're talking about today. Back to our framework, you will have already written down JVPs with a side of mustard. And the J stands for jurisdiction. Then we move into venue, parenting, equitable distribution, alimony, child support, and then everything else, which is almost always attorney's fees. Now, the mustard is its own little special ingredient. Not all sandwiches go well with mustard, but some of them do. So we're going to talk about the modification proceedings and how that affects your analysis. But this analysis, again, unless the writer tells you that they want specific questions answered, this is the framework that you go through in this order for every family law essay. Let's jump into jurisdiction. This lecture will not go through your general personal jurisdiction and subject matter jurisdiction. Your federal international shoe type cases, and at the state level, that's the Venetian salami cases, where you're dealing with personal jurisdiction and subject matter jurisdiction, still apply. Those are better covered under constitutional law, civil procedure, and other those components. Family law has two additional unique components for jurisdiction. The first one is residency requirements. One spouse must have been a resident of the state of Florida for at least 6 months before the court will have subject matter jurisdiction over the marriage. Now, if only one spouse is met the residency requirements and the other spouse doesn't have any connections with the state of Florida and otherwise hasn't consented to personal or subject matter jurisdiction, the only thing the court can do is dissolve the marriage. But if a spouse has only been here for 5 months, they've got to wait another month until they hit that 6-month threshold. The most fun statute, perhaps in family law, is the Uniform Child Custody Jurisdiction Enforcement Act, what I will refer to and what's commonly referred to as the UCCJEA. What this says is that the court, a child must have been a resident of the state of Florida for at least 6 months before the court will take jurisdiction, unless the child is under the age of 6 months, at which point the state that the child was born in is the home state. And that's really the question under UCCJEA, is defining what we call a home state. And so that home state only applies once that child's been here. So if this child's been here 5 months and 29 days, Florida is still not the home state for another few days. However, Florida can take emergency jurisdiction if it's not the home state over a child if there is some threat of removing that child from the jurisdiction, at which point you get the wonderful task of having what's called a UCCJEA judicial conference. All you really need to know about that is that the judges converse between the two states to decide whether that emergency jurisdiction is going to remain or not. So the UCCJEA, your key word, establishes the home state of the minor child. The second issue is venue. Venue is different for dissolution versus paternity. In a dissolution action, the correct venue is where the marriage was last intact. So if the party's marriage was last intact in Orlando, mom moves to Tallahassee and dad moves to Key West, Orlando is the proper venue. Now, that being said, unlike jurisdiction, the parties can consent between themselves to a different venue. Paternity paternity applies to a child that's born out of wedlock. Paternity cases, the proper venue is either the county in which the child resides or where the father resides. The moving party has the ability to frame the venue that they want to in paternity. So those are your specific venue components. So let's jump into parenting. That's the P of our JV peace acronym. So we've already gone through the JV. Now we're jumping into peace. So parenting, I never want you to use the word custody again. Under Chapter 61 and in the paternity case, the word custody does not exist anymore. It is called time sharing. Time sharing, and any time that you have a minor child, the court must consider the best interest of the minor child when it enters into the required parenting plan that is mandated for all divorces and paternity cases where there's a minor child. Now, it is insufficient in your time sharing analysis to simply say that the court will consider the best interest of the minor child. What does that mean? The court is guided by factors under Chapter 61, and you should probably read them. But for purposes of right now, the major ones that we see pop up not only in practice, but on the exams are typically which parent has the ability to foster a healthy relationship with the non-primary parent. This kind of goes towards your parental alienation issues. You will also see which parent can provide the most stability. You will also see substance abuse as one of the factors, mental health, and any type of violence or sexual violence or those types of components. But these are only factors because the last factor under the time sharing factors is anything else the court deems applicable to the family. So these are just guiding principles. These are not elements such as the formation of contracts, torts, or in your criminal cases. But when you go through the best interest factors, identify the problem areas, number one, for whichever spouse is, one of the spouses will almost always have a problem, some type of substance abuse, some type of violence, something of that nature, or another parent will keep a child from the other parent, not allow communications. The other component is which parent has been the stable factor for the children, who has provided the household, who's taking care of their day-to-day needs, who takes the child to the doctor, those types of things. Your parenting plans govern every component of your time sharing with your spouse. The parenting plans include transportation, communication, regular reoccurring time sharing, holidays, extended breaks. There's 3 types. There's a normal parenting plan for parents that are generally live close by and get along well. A long distance parenting plan, which is when parents reside relatively far apart. So where it's not feasible for a child to just go over for a weekend because of the transportation expenses or the time for travel. And then you have your safety focused parenting plans. And that's where one parent is dangerous to the other. So in your analysis, if you can find that one of the parents may be dangerous, if they're allowed unsupervised contact with a minor child, use the phrase that the court may consider a safety focused parenting plan in order to protect the minor child. The second component of parenting is what we call decision-making authority. This is in a lot of states, this is what they call legal custody. We call it parental decision-making authority, and there's 3 types. There's shared parental responsibility. Shared parental responsibility specifically is where the parents have to make major decisions regarding the minor child together, and if they cannot reach that agreement, then the court makes that decision for them. Major decisions include non-routine medical procedures. It can include religion, and it certainly includes education and mental health. Although 2 components of that, mental health, either parent can choose to enroll a child in order to seek mental health counseling for the minor child. Shared parental responsibility is the norm. It does not affect the day-to-day decisions. One parent does not have to call the other parent and say, hey, I'm stuck between going to Chili's or McDonald's. But if it's, hey, should we get this procedure or not? Those are the types of things that must be done jointly. Now, ultimate decision-making authority, this is often misconstrued, but it does come into play on the essays. Ultimate decision-making authority only applies when there's an inherent conflict between the parties on certain components of the minor child's life. And the statute says the court can grant shared parental responsibility as to some components and ultimate decision-making authority as to others. The best example of ultimate decision-making authority is for one parent who believes in vaccinations and one parent who does not believe in vaccinations. They will always have this conflict. The court knows that they're going to continue to come back. And so the court says, mom or dad, you get to make this decision. You have to tell the other parent, but if you can't agree, then one parent gets that ultimate decision-making authority. The statute does not allow a blanket. It must be identified which components. Now, it could very well consist of all the areas of decision-making authority, but it must indicate that. And then you have sole parental responsibility, and this is the rarest, and this is really reserved for your very, very bad parent. Sole parental responsibility means that the other parent doesn't even have to consult with the other parent in order to make those decisions. This is for one parent who may be incredibly violent, mental abuse, committed sexual abuse, those types of things. So sole parental responsibility is really a rare occurrence. So after parenting, we get into equitable distribution. This is property. There are only 2 types of property. There's marital property and non-marital property. Marital property is all the property that's been acquired during the marriage or has been commingled from non-marital property. Non-marital property occurs if the property was brought into the marriage or was gifted or inherited and not commingled. Now, the biggest component of non-marital property is when the property is commingled. First, as to perhaps real property. If I own a house for 20 years and then 5 years ago I got married, and to express my love to my spouse, I decided I was going to put her on the deed. 1 year later, we get divorced and I say, that's my property. I've owned it for 25 years. No, she now owns it and it is now a marital property. The other component is cash, and you're going to see this quite a bit. Cash is like water. When one party's cash is commingled with another party's cash, then it's like you can't tell which glass of water, if you pour them together, which glass of water it came from. So if I have an individual bank account that I've never commingled, and then I take half of my individual money and I put it into our joint account, that money is now marital property, even if I take it out later and put it back into an individual account. It loses its non-marital component. But for non-marital property, and this has been tested, this is one of the most seminal cases in family law, and it's called the Ka case. And what Ka had to deal with was a marital interest in a non-marital property. And what it held was that, for example, if I own a house and I've had it for 10 years and then I get married, but I don't place my spouse on the deed, but the house increases through marital efforts, which includes, even if my spouse stays at home, my income pays for the mortgage, pays the taxes, otherwise keeps the property from belonging to a third-party creditor or the state. That is a marital interest. And so the analysis then is that the spouse gets 1/2 interest in the increase in value from marital efforts from the date of marriage to date of separation. Here's a quick example. If I buy a house for $100 and then the following year I get married and that house is valued now at $200, that $100 increase in value or decrease in principal remains a non-marital asset. However, during the course of the next year, that property increases in value from $200 to $300. That is a marital interest, and my spouse would be entitled to $50. So if we sell the house upon separation for $300, I'm going to walk away with $250 minus the expenses to pay out the mortgage, and my spouse will walk away with $50. Now, I realize we're not going to buy a house for $100 or $200, but please, I'll leave my contact information. And if you do find houses for $100, please contact me immediately, and you'll find yourself a new business partner. This is the other critical component of equitable distribution. Unlike parenting, alimony, and child support, when the court enters a final judgment distributing the property, and assuming there's no motion for rehearing or appeal, it becomes final. The court loses jurisdiction over the distribution of that property. What is mine is mine. What is hers is hers. I can't go back and ask the court subsequently to place something that's hers now mine. Now, the court can enforce performance components, such as if the parties are required to sell a home within 60 days post-judgment, the court can enforce those performance, but it cannot redistribute that property. Alimony is, at the time of this recording, alimony is in flux. This alimony applies only as of April 1st of 2022. Now, if the alimony law is changed, as many suspect it will be, there's a bill sitting on the governor's desk, then completely disregard this section of this video, and we will make another video only on alimony with the most current information we have. So please, no matter what session you're watching this, no matter what year it is, double check, just Google Florida alimony and make sure that the bill was not signed. If it was, ignore this. Now, the poll star for alimony is one spouse's need and the other spouse's ability to pay. they both must be present in order for the court to award alimony. What is need? Need is not creating a savings account. Need is usually based on the financial affidavits and is a deficit, indicated by a deficit for the party that is in need. Need is typically the easier component to litigate in alimony, but this is why alimony comes after equitable distribution. Let's say that a spouse makes substantially less than the other spouse, but during the equitable distribution, that spouse got stock investments and a huge chunk of money that in and of itself could sustain the lifestyle that that spouse became used to, then that can decrease the need. So the equitable distribution does play a role in the alimony analysis of need. And then the second component is if the court finds that one spouse has a need, it must find that the other spouse has an ability to pay. Now, there's a seminal case that came out of Florida that I was a part of, and one of the components at the trial level was need and ability to pay. My client clearly had a need, running a deficit of $4,000 a month, and that was necessary to have any resemblance of the lifestyle that the two enjoyed during the marriage. The other spouse made $25,000 a month, but his expenses based on the equitable distribution, based on some bad business investments, he had to spend $27,000 a month to maintain the assets. The court found he did not have an ability to pay. Alimony is not an equalization of income. So take that example and know that ability to pay is not just your net income, it's also based on your ordinary and necessary expenses. Now, at the time of this video, the types of alimony are temporary alimony, which is alimony that is awarded only during the duration of the litigation. Temporary alimony terminates upon the entry of a final judgment. Rehabilitative alimony provides for a rehabilitative plan. For example, one spouse who is re-entering the workforce and they need additional training. Maybe they stay-at-home mom and they need 6 months to go to real estate school and pass the real estate test before they become financially independent. The rehabilitative alimony is intended for this component, but it must come with a rehabilitation plan. Bridge the gap alimony is exactly what it sounds like. It bridges the gap between one stage of life or another. One area that this can come into component is spouses later in life, where they haven't quite reached the threshold for Social Security benefits, that alimony may bridge that gap between their current status until they're able to receive that additional income. Durational alimony is no more than the duration of the marriage, and permanent alimony is what it is, except for it's not. And we're going to talk about that in a minute. But before we talk about, we need to figure out which ones these types of alimony apply to. As of the time of this video, there are 3 stages of a marriage. Short term, which is 0 to 7, that's going to allow you to seek temporary, rehabilitative, and bridge the gap. A midterm marriage is 7 to 17. That's going to allow you to seek temporary, rehabilitative, bridge the gap, and durational. And then there's long-term, 17 plus. It's going to allow you to get temporary or rehabilitative or bridge the gap or durational or permanent alimony. Now, permanent alimony there's a seminal case that's called PIM. Now, this is one of the biggest changes that may come out in this law, is that permanent alimony, as we know it, will go away. Now, permanent alimony is entitled to be for the duration of either the payor or the payee's life. But as you'll see in modification, when we get there, there are some things that life events that will trigger a change in permanent alimony. So keep these in mind as we decide whether we're going to put mustard on our sandwich or not. A prenuptial and postnuptial agreement cannot waive temporary alimony, but it can waive any of the other post-judgment types of alimony. There are certain factors that we're not going to go through for time that are listed in 61.16. That includes the standard of living, the needs of the parties, the contribution to the marriage, and those types of things. And alimony, as we said, we have to go through the piece analysis in order, because alimony constitutes income to the receiving spouse, which will increase their net income, adjusting the child support guidelines, and it's a decrease in the paying spouse's income, reducing the amount available under the child support guidelines. That gets us to child support. Child support is based on a calculation. That calculation is in the statute, and the easiest way to find it, if you're a hands-on type of learner to understand, is to look up the child support guidelines worksheet. Child support guidelines worksheet will tell you that to calculate child support, you take the net income, that is the gross income minus allowable expenses, and those are allowable expenses under Florida law, not for purposes of the IRS. So for example, you can reduce your gross by paying taxes, mandatory union dues, and your health insurance, but you don't get a credit for perhaps a home office like you would under the IRS. Again, you can also reduce that if you have alimony payments that you have to make, and then something called a Speed Smith credit, which we'll get to under determination of net income. There are two types of calculations. There is a basic calculation, and that's where one parent has less than 20% or 76 total overnights per year. And that does not take into account any type of adjustment for time that that parent will be spending with the child and expending those funds directly on the child. And then you have the gross up method. And so anytime you hit 77 overnights for at least for the one parent, then there's a different calculation in there. And what this calculation does is try and take into account that if, for example, I have my child for 40% of the time, for 40% of the time of that child, I'm going to be paying those expenses. And so I very well could be paying some of the tuition and clearly food costs, because I want to make sure my child lives. And so I won't have as much of an obligation to my other spouse. Now, here's the interesting thing on a gross up method is even if you have an equal time sharing schedule, and please don't put this on your essay, equal time sharing does not mean no child support. If you have one parent that makes $10,000 a month and another parent that makes $5,000 a month, and they have an equal time sharing schedule, then the parent that pays $10,000 a month is still going to pay child support. This is a huge misconception, not only for non-lawyers, but some lawyers actually as well. So determination of net income, we talked about allowable deductions, but the other component of that is for purposes of the guidelines, you will also see some adjustments based on childcare costs that get shared pro rata, reoccurring medical expenses and medical insurance. Now, I said that there's a something called a Speed and a Smith credit, and I don't think you'll see this, so just it's kind of a fun name and you probably won't forget it. But a Speed Smith credit, it's two separate cases, but the concept is the same. If I have part of my income goes towards the care of another child, perhaps a child, I have a firstborn that I also pay child support for, then the court will take into consideration those expenses or those orders that I pay towards another child when it calculates my child support order. I haven't seen that on any essays yet, but doesn't mean that it won't exist. So that gets us to everything else. The seminal case for attorney's fees is called Rosen v. Rosen. It is as popular in the family law community as International Shoe or Marbury versus Madison, perhaps for other attorneys. Attorney's fees, you run the same analysis of need and ability to pay that you would otherwise do with alimony. What this does, the theory behind attorney's fees is that both spouses, despite one spouse perhaps having control of the finances or that regular income where they can afford the continuing services of an attorney, the other spouse should have equal access to competent counsel. But again, just because there's a need does not mean there's an ability to pay. There's a second prong to Rosen where regardless of need and ability to pay, if one party is engaging in vexatious litigation, extending it out, increasing the expenses, trying to snowball and force a result by outspending, the court can bypass the need and ability to pay analysis, look at the totality of the circumstances, and still award attorney's fees. So that is the case of Rosen v. Rosen. So here's the mustard. to modify a parenting plan, alimony, or child support, not all types of alimony, but alimony or child support, you must have a substantial change in circumstances. Now, when we talked about parenting, what I told you with the poll star was the best interest of the minor child. That always remains true. But if I have a parenting plan that's been entered on a final judgment, I need to show the court that something changed between the time the judgment was entered and the time that I filed the petition. That change must be substantial, material, and unanticipated. We shorten it by saying substantial change in circumstances, but if you really want to take your family law essay to the next level, make sure you say substantial, material, and unanticipated change in circumstances. Notice it doesn't say substantial, material, or unanticipated change in circumstances. You must have all three, and most of the time the analysis comes down to whether the changes were unanticipated. A child going from 3rd grade to high school is not unanticipated, but there could be a lot of other things at play. Perhaps one parent, this was tested, one parent post-dissolution became addicted to substances. That's substantial, material, and unanticipated if it affects the safety of the minor children. Those are grounds to file. Parenting, the court will always maintain jurisdiction over a minor child until the child ages out. Technically called that the disability of non-age is removed, but ages out, becomes an adult, gets married, joins the military, those types of things. So that's always modifiable. Equitable distribution, never modifiable. Alimony depends on the type. Some of them are not, but permanent alimony is. And permanent alimony, where you probably will see the substantial change in circumstances in alimony, on a permanent alimony, and this is where it gets litigated all the time, is what we call a PIM case, P-I-M-M. It's a case from the Florida Supreme Court. And you still have to run the analysis of whether there's a substantial, material, and unanticipated change in circumstances. Now, as we all get older, some of us hope to retire. I certainly do. And that's normal, that's anticipated, except under Florida law, they say that that does still constitute a substantial change in circumstances. So retirement, so long as that retirement is at a reasonable age that's consistent with the community, it's the poll star is 65, but if your profession, perhaps retirement is generally earlier, or people stay in your profession later, it does come down to the profession or the industry standards, but retirement can either terminate or reduce the payor's obligation to pay alimony. It gets you past the threshold of substantial, material, and unanticipated change in circumstances. Now, the easiest modifiable component in family law is child support, because you can modify child support anytime there's been a change in $50 or 5% of the obligation to the other parent. What does that mean? If you get a $3 raise at work, chances are you're going to be looking at a modification in child support. Likewise, if you get a reduction in your income at work, the court can find that substantial, material, and unanticipated. So child support remains one of the most hotly litigated and fluid and easily modifiable components of family law. Now, modification proceedings, this is important, only apply if there's already been a final judgment entered. You never put the mustard on a sandwich that doesn't have a bite out of it yet. So let's go over some fact patterns together. We'll see how this kind of plays out. So the first fact pattern is that we have John and Pam, and they divorced about 6 years ago. Now, John is 66, and he's a retiring commercial pilot. And we're going to assume that for a commercial pilot, that's a normal age to retire. I am not personally a commercial pilot. When he retires, he's going to have a reduction in his income about 50%. Now, Pam has also had a significant decrease in her income because of her own retirement. John comes to us and says, hey, I have a permanent alimony obligation. I want to modify it. This is our PIM case. John's reduction in income based on retirement, which I'm certain he was planning ahead on, will get us past a substantial change in circumstances. Once we get to that point, then we are back to need and ability to pay. So the court will consider Pam's need, which probably increased because she had a decrease in her available income, increasing her necessity for additional alimony. John will also, his ability to pay will be analyzed based on his financial affidavit and what resources he has after his reasonable and necessary expenses. The next one is that you have Steve and Sue in this particular circumstances, and they're in the middle of a dissolution proceeding, so we're not applying any mustard on this one. Sue wants to have sole parental responsibility, but Steve has an equal time sharing schedule in practice because we don't have a final judgment yet. But Sue makes all the decisions related to medical, religion, and school because it's just more convenient for the parties. Other than vaccinations, the parties otherwise do not disagree about major parenting decisions. So Sue wants to know, is this a good case for sole parental responsibility? The answer is no. Clearly, she's not afraid, or Steve doesn't present a risk because Sue lets the children go with Steve, and there's no reason why he can't provide that input. It's not the type of case where sole parental responsibility will come into play, but you still need to analyze it. Don't forget it because you're going to get bonus checkpoints. So then we need to consider, okay, what about ultimate decision-making authority? Well, this is misleading because Sue makes all the decisions just based on convenience, but they're getting divorced. Those types of conveniences don't exist anymore because they will be living separate and apart. They'll be co-parenting rather than spouses. Because they don't have an inherent disagreement on medical, religion, or school, the court will order shared parental responsibility for those components. However, as to vaccinations, perhaps, the court will say, Sue, you are in control. So the court may order shared parental responsibility, except for ultimate decision-making for Sue as it relates to vaccinations or certain components of medical. A few more, actually only two more. So now we have Kevin and Karen. And they're in initial proceedings, so we don't have any mustard on this one. He bought a house 10 years ago, and he's been married for 10 years. So he's owned the house for 20 years, and for 10 of those years, he was married to Karen. Karen's never been placed on the deed, so this house has not been commingled and is not a marital asset. He is the sole earner of the marriage, and he has paid the mortgage and the taxes for the entire marriage. The starting value of the home, looks familiar, is $100,000, and then it increased to $200,000 at the marriage, and at the time of separation, it's valued at $300,000. That's when we value, for dissolution cases, when we value the value of property, we value it on the date of separation or as close thereto as we can. So the question is, Kevin really wants to know, what do I have to give her out of the house? And reasonably so, he says, I made all the money. I paid all the mortgages. I paid the taxes. Karen just took care of the kids. Well, or she mowed the yard, or she made sure the pool was clean, or she made sure the house was neat and tidy. But Kevin says, that's not enough. Well, the truth is it is. Kevin's income during the course of the marriage is a marital asset. It's not his money, it's the marriage's money. And therefore, since that money was used to maintain a marital asset, Karen has a interest in his non-marital asset under the case we called COB. So Karen will be entitled to $50,000. That's the one half of the increase in value of the home from the date of marriage until the date of separation. Our final example, we're going to deal with Bobby and Barbara. They are in initial proceeding as well. And Bobby received a $500,000 inheritance. He's a very lucky guy. And he's probably not going to spend it to go to law school. But if he does, I hope he watches this video. He first deposited the money into his own account. So Barbara is not on that account. And so that money still maintains its non-marital component. Now he wants to invest the money. So he transfers it to a joint Chase savings account. And then he moves it into a certain ascertainable stocks that are in his name alone. So what happens? The money that was invested, that money that was placed into the joint account, into the savings account, that $500,000 is now marital. It's like water. When you pour two cups together, you cannot figure out which atoms of water came from which cup. Now, when he then moves it into stocks, and I had to use the word ascertainable stocks on purpose, stocks are a little bit different because stock is actually you own a portion of a company. So if, for example, let's say he owned 1,000,000 shares of Apple, he's a rich guy, and 1,000,000 shares of Google. If he takes the $500,000 from the joint account and he buys a third stock, and let's say that's SpaceX stock. I don't even know if they're public. I think they are. But if he does it in SpaceX, that does not affect the ownership interest in the Apple and the Google stock because those values are still ascertainable as a non-marital asset. However, if you were to take the $500,000 and invest it into his Google stock, then it becomes commingled. I want to thank everybody for joining me today. My name is Jeremy Simons with Ibis Prep. This has been a family law part of the Ibis Prep video course. And I hope to see you in individual tutoring, not only on family law, but for me personally, contract, civil procedure, evidence, both at the MBE and the state levels. And greatly appreciate you watching the video. Thank you very much.